to today's talk show. I'm your host, Amos, and with me are Bryan. Say hello, Bryan.
Hi.
Cornelius.
Hey,
Hi. Kenny.
Hi.
And Raziq.
hello.
Hi. Hey, guys. Thank you for coming. These guys are from the Independent Analyst Group, and we're here to talk about Australia's tobacco plain packaging law. Now, according to the case, Australia's main objective in introducing the law is to reduce the influence of tobacco products so as to discourage any potential and current consumers to purchase the product as well as to increase public awareness and thus public health. However, proponents to the law, most notably tobacco exporting countries such as Honduras, Dominican Republic, and Ukraine, has raised concerns of the law. Their main contention being that it is an infringement of their intellectual property rights. But if you guys notice, historically, tobacco companies have been using trade agreements to forcefully open up new markets in developing and poorer countries. And we all know the effects of consuming tobacco and its underlying health concerns. It is highly addictive and lethal. Efforts by countries to ensure public health is constantly stymied and challenged by tobacco companies by using trade agreements as the excuse. Now, the question to you guys would be whether this law that is Australia introduced, is it a health issue or a trade issue? Mr. Bryan, can I get your thoughts on this?
Yeah, so I think it's a health issue because, like what you said, it's highly addictive, and this can pose like a great risk to the younger generation. As studies show that it has negative effects the cigarettes have on the younger generation now.
All right. So, what about the World Trade Organization itself? Should they have the right to legislate in the country's law with regards to the country's public health?
As to that, I think they shouldn't be able to legislate laws because the WTO primarily is a trading organization where their function is to facilitate trade among nations. So this means that the WTO are going to prioritize the rights of corporations over the health and human rights. This can impact the health of citizens where tobacco control is needed. So an example of this would be the US-Singapore Free Trade Agreement Implementation Act in September 4th, 2003, where all tariffs of goods traded between them are eliminated. So this meant that the tariffs set on tobacco were nullified due to the trade agreement, causing an increase in cigarette distribution. So in my opinion, I think they shouldn't be able to enact laws.
I see. Thank you, Mr. Bryan. Uh, Mr. Cornelius, what about if the World Trade or WTO do not have the right to legislate in another country's law? Uh, should they be excluded from any WTO agreements?
Yes, the health issue should be exempted by the WTO agreements as long as it does not violate the company's right or any trade policies enforced by the WTO. Australia addressed several issues that their plain packaging law does not violate the WTO agreements. For instance, there were complaints made by other countries that Australia breached the Article 20 of TRIP agreements, whereby the country make the product packaging unable to be distinguished among its competitors. Australia refuted the statement by stating that the usage of brands, trademarks, and names are still allowed in the product packaging, except for the usage of advertisement. So consumers are still be able to distinguish the products based on their brands. And this shows that the plain packaging law does not breach any of the WTO agreements. In fact, the WTO acknowledged that the government needs to intervene in the tobacco market because the market failed to give more exposure regarding the consequences of tobacco to consumers' health and their addiction. Hence, it is understandable that Australia made their own plain packaging law as a method to reduce the consumption of tobacco products and to raise the public health awareness. Secondly, the reason why this health issue should be excluded is because it is closely related to the World Health Organization agreement, such as the Framework Convention on Tobacco Control, which is in a short form FCTC. The WTO agreements such as TRIPS, TBT, GATT only covers product issues in general, but FCTC specifies its law policy on tobacco products only. For example, in the Article 11 of FCTC, it stated the criteria on the packaging and the labeling of tobacco products that all of the WHO party members must follow. In fact, the plain packaging law enforced by Australia also complies with the article of FCTC as mentioned earlier, which is regarding the packaging and labeling of tobacco, and the article 13 of FCTC, which is about the advertising of tobacco. So this contributes to another reason why this health issue should be excluded in the WTO agreements. It is because of the redundancy in terms of law when being compared with the WHO and the WTO agreements. Australia will be caught up between the two agreements. Since it is a health issue, the plain packaging law should focus more towards the FCTC because it is related to tobacco products. As mentioned earlier, WTO agreement only focus on the product issues in general. So that justify why this health issue should be excluded in the WTO agreements. Thank you. Back to Amos.
All right, thank you, Mr. Cornelius. Mr. Raziq, are you on? Uh, Mr. Raziq, with regards on what Mr. Cornelius have just said just now, does it make any differences in the case when the complainant countries are from developing countries?
To me, this is a complicated issue, right? I see this issue as there are two sides of the coin regarding this issue. The first side is whether the country is affected economically by the stricter packaging tobacco laws imposed by the importing nation, which is Australia. And the other side of the coin is whether the country is is not affected economically by the stringent tobacco laws by the importing nation. And I would also like to take note that that the whole WTO system, right? The poor countries definitely face a hard battle when it comes to accessing their market rights through formal dispute litigation, as they are almost certainly disengaged when trying to enforce their rights to dispute formally within the WTO frame. Um, with regards to this issue, yeah, I think the complaining countries, which are Honduras, Dominican Republic, and Ukraine, um, I think they are the latter side of the coin, which is they are not really affected economically, to say the least. The reason why I said that is really because there's no statistic that indicated how much they have exported to Australia, their tobacco products to Australia, as well as they don't really face any ramifications because of the packaging law. Yeah. Even if there is a very small amount that for some reason those countries did export in some way, I don't know how it works, but in some way, very small minuscule amount of it did manage to land into Australian shores. I'm pretty sure it doesn't really affect them economically or any way possible. Like, to be fair, yeah, one of the largest exporters and most important tobacco producing countries, which is Indonesia, who also lodged opposition regarding this law, even they only produce like only export. I'm sorry, only export like 1% of their tobacco products to Australia. So with that being said, I believe that it is not really necessary. It doesn't really matter that the complaining countries are from third world countries, because first of all, as I said before, economically nothing happens to them directly. Secondly, no relationships were lost because of it. And the third one is the barriers to trade between all those countries. It's still the same. Like nothing happens to anything. Nothing happens to both of them, regardless of what you think. This whole issue, this whole complaint, this whole dispute, I think to me is because of the influence that the transnational tobacco companies, like for example the big companies like Philip Morris, the big tobacco companies, they're actually like they're paying they're paying the legal fees for the complainant countries to lodge the report on behalf of them, because obviously Philip Morris is not really in the WTO. The WTO is mainly about nations, not companies. So this is the way that, so the reason actually why this company or the companies influence the complaining countries to launch this report is because they want to try and influence the trade policies, because they want to pursue their own corporate interests. So yeah, I think that's it.
All right. Thank you for those enlightening comments on the case, Mr. Raziq. I would like to ask Mr. Kenny on his thought. What would you recommend to the dispute settlement board with regards to this case?
All right, thanks, host. Greetings, everyone. Indeed, this tobacco plan packaging is a tough issue for World Trade Organization dispute settlement body, the DSB, to resolve. As you know, this is a controversial between a health and a trade issue. Since Bryan mentioned in previously, this is related to the health issue. I would suggest that the DSB could refer to the World Health Organization for advice. The Technical Barrier to Trade (TBT) and General Agreement on Tariff and Trade (GATT) from the WTO World Trade Organization cover generally in the general product issue, but not on the tobacco. But however, in the World Health Organization, they have a better framework or treaties regarding such issue. For instance, as mentioned by Cornelius, World Health Organization adopted the Framework Convention on Tobacco Control, which short form as FCTC. There's a section in the framework, for example, the Article 6 regarding the taxes and price policy on the tobacco product to control the use of it. Next, the DSB may suggest the Australian government to implement alternative tobacco control policy rather than just the plain packaging law. Australian government may increase additional tariff, quota, or any tobacco goods or quota for any tobacco goods in their market. By increasing the taxes, it will decrease the purchasing power of the smoker and decrease the tobacco consumption in the nation. Furthermore, Australian government may increase the licensing fee for tobacco seller and limit the new license application so that it limits and narrow down the distribution channel for the tobacco in the Australia. All right. Lastly, for DSB, they may suggest the World Trade Organization to reverse or revise the trade agreement regarding the tobacco. As mentioned, the TRIPS, Technical Barrier to Trade (TBT) and GATT from World Trade Organization only cover general product issue, but not on the tobacco issue. Hence, World Trade Organization may include additional tobacco product policy, which may include the packaging for the tobacco product, export quota for the tobacco, licensing for the tobacco seller. Hence, it provides better monitor and control over the tobacco product export. All right, back to you, Amos.
I see. Thank you, Mr. Kenny. Now, to summarize, I would like to summarize what we talked here today. So the case itself is about health issue with the WTO do not have any right to interfere in the nation's decision with regards to making a law aimed towards tackling tobacco issues. Yes. So from the case study, we can also see that the three complainant countries, the major complainants are Honduras, Dominican Republic, and Ukraine. They are not the key exporter for tobacco to Australia. As such, they do not have much influence on the plain packaging issue itself. It's more towards them being a puppet of big tobacco companies such as Philip Morris. Lastly, with regards to the dispute settlement boards, you guys have recommended for Australia to follow the WHO guidance and as well as implement tobacco control policies and revise the WTO trade agreements on matters of tobacco only. Yes?
Yes, that's correct.
Yes.
Yeah, I see.
Yeah.
So if that's the case, then I believe we have concluded our talk show for today. Thank you everyone for coming.
Right. Thank you.
Okay,
Thank
thank
you.
you guys.
Bye.
Thank you.
All right, bye.
Bye.
Ciao, ciao, ciao.